here we are. Let's begin with the facts as Afrifa states them, stating to the General Legal Counsel what he says are the truth of the facts. So he says that the truth is that a fee of 1 million was agreed, out of which the petitioner paid 300,000 and undertook to settle the remainder later. So Afrifa is saying that the fees that he collected from the client is 300, but 300 was part payment of 1 million that was agreed. He said, I represented the petitioner in the Court of Appeal, Cape Coast, and the Supreme Court, and also performed other duties for him, particularly at the National House of Chiefs. Now, this is very important. Afrifa says here also that the client was so impressed and satisfied by his services that he wanted to dispense with his substantive lawyer. But he, Afrifa, told the client that he did not come into the case to supplant the lawyer, and that he, Afrifa, will stop the conduct of the case if the other lawyer's services were dispensed with. This is also a very important aspect of the matter, because a question that will be raising at the end of the situation. Afrifa says that, one, he did work for the client in Cape Coast Court of Appeal. He also says that, he says categorically that the client was very impressed with his work. So let's move on. At the end of July 2020, the petitioner informed me that friends of his who were highly connected politically had taken him to see the Chief Justice, who had agreed to help him win his case on condition that he drops my good self handling as the lawyer handling the case for him and engage Adom-Otchere Esquire in his stead. So that's another allegation that he's making. Afrifa is saying that the client told him that the people had taken him to see the Chief Justice, and that the Chief Justice said that they should change the lawyer. Okay, let's move on. He said the client then informed Afrifa. This is the dastardly part. This is the very, very terrible part. He said the client informed him that the Chief Justice had demanded a bribe of $5 million United States dollars for a successful outcome to his case, and that he, the client, had already paid $500,000 to the Chief Justice. This is a very serious allegation. I'm not surprised that the Chief Justice invited the Criminal Investigations Department of the police to have a look at that. This is a very serious allegation that Afrifa makes. Okay, let's move on. Afrifa says the client further indicated that he, the client, was hard-pressed to raise the remainder of the of the 5 million, which will be 4.5 million, by the way. So he says that the Chief Justice was asking for 5 million United States dollars. He, the client, had been able to generate $500,000, which is what, 10% of what he claims that the Chief Justice is asking. And so he's left with a whole 4.5 million to pay. Okay, now, he says that he asks Afrifa. Afrifa says that the client asked him to refund 300,000 paid to him as fees because he, Afrifa, had in line with the advice of the Chief Justice, because he, the client, had in line with the advice of the Chief Justice, engaged Adom-Otchere as solicitor to continue the case before the Supreme Court. Okay, Afrifa says here that out of a sense of dignity on his part, he told him that he would rather refund the entire 300,000 paid to him and bear the cost of air travel, hotel bills, and other expenditure incurred by he, Afrifa, the lawyer, in prosecuting the case. So here, this is where our curiosity begins. Afrifa agrees to refund everything that the client has ever paid him. Things that he charged as a result of legal fees, which is a legitimate charge, of course. He agrees to refund the legitimate charges that the client paid him. And he doesn't just agree to refund it in cedis, the way it was paid to him, but he agrees to refund it in dollars, $50,000, to facilitate a payment to the Lord Chief Justice, a panel member of the matter, because the client is now short of 4.5 million United States dollars, being the alleged demand of the Lord Chief Justice, a panel member on the matter. This is where our problem starts, that the lawyer says that having impressed the client such that the client wanted to retain him, the client comes back to him and says that people have spoken to me and I've been to the Chief Justice. Chief Justice says that I will only win on condition that I take you out, number one. Number two, I'll also win on condition that I pay him $5 million. Of the $5 million, I've already paid him 500,000 United States dollars. I'm left with 4.5 million. So, Mr. Great Lawyer, I'm so impressed with you, but hear me out. You have to give me back the money. The money that I gave you, you have to give it back to me, the 300,000. Can you give it back to me? But don't give it to me in cedis. Give it to me in dollars. what kind of story is this? I mean, I don't know whether Johnson Asiedu Nkatia, before he did his press conference, you see, I always talk about this. I will never stop talking about it. Did they go through thought process? What kind of story, what story is it? I mean, there are many lawyers in the NDC, many lawyers, many good lawyers in the NDC, many seasoned practitioners in the NDC. Did they ask them that, you are practitioners at the bar? You know, I'm not saying Afrifa is wrong or the Chief Justice is right. The General Legal Counsel will agree, will deal with that. But I agree with the NDC that there has to be a public hearing because it's a matter of high public interest. I definitely agree with the NDC on that. But my concern is the story, without you knowing anything. I don't know Afrifa, I don't, just the story, just it. It doesn't add up. Any class 1 student of English literature will look at this story and raise fundamental questions about it. Anyway. No problem. Okay, so Afrifa says here that we aggregated the 300,000 paid to me as being the equivalent of 50,000 United States dollars, which I was to refund to him without any timeline being indicated. He said he wanted the payment in dollars because he was raising the remainder of the money to be paid to the Chief Justice, and the currency was the dollar currency was a currency of choice for the learned Chief Justice. That's what the guy says. Okay. On the 27th of January, he paid the guy $25,000 to the petitioner, and subsequently he's paid $15,000, making it a total of $40,000. And he says that when he's coming for the event on the 15th of July, when he appears before the committee, he will have $10,000 in his hand. He denies any other thing the petitioner said in terms of the gymnastics, etc., etc. Now, let's see the letter that the Chief Justice wrote to the police, and then we'll be bringing this matter to an end. But these are the fundamental questions that we are asking. The fundamental questions we are asking is that, how does a lawyer return his fees, the fees that he charged, for which work, for the impressive work that he did? How does the lawyer return the fees and returns it in dollars? Why is the lawyer punishing himself after doing such a good job? What's the point? And why is a lawyer releasing money to somebody who is telling him the purpose of the money? The guy is telling you that, I'm going to use your money to commit a crime, a bribe. I want to influence the Chief Justice in bribery because according to him, he has asked for it. So bring me the money that you have legitimately earned, change it to dollars, and let me go and pay the Chief Justice. And some people think this is not hearsay. I really don't get it. I'm totally shocked. Okay, so this is the letter that the Chief Justice then writes to Mr. Kenny Eboa, who is the director of CID. Let's look at the letter in detail if you have it. Okay, it says, the attention of His Lordship, the Chief Justice, has been drawn to copies of letters from lawyer Akwesi Afrifa Esquire and his client, the plaintiff, in the matter of, he mentions the case, to the disciplinary committee of the General Legal Counsel, and which letters are making rounds on social media. His Lordship is saddened with that without any shred of evidence, his name has been dragged into the sordid and potentially criminal matter. His Lordship confirms that he does not know the plaintiff and has not met or seen him anywhere except in the courtroom when he rises to announce his name. Okay, His Lordship assessed that he had no personal interaction either with the plaintiff or his lawyer on this matter or in any other matter. His Lordship further asserts that he has not demanded or received any money from any person to influence any decision in this matter or any other matter. Indeed, the records will show that the plaintiff unsuccessfully petitioned for the recusal of His Lordship, the Chief Justice, and Justice Victor Jones Maulom Doche. So this is an important information. So the Chief Justice is saying that, one, I don't know the person, I have never seen him, I've never been influenced. But even if you want to look at the circumstances of the case, that's what the Lord Chief Justice is saying. If you want to look at the circumstances and the record of the case, this client who says that I've asked for 5 million so that I can do the case for him, I can make it better, and I'm asking him to change lawyers, he has ever appealed to the courts that I, Eniyebo, be taken off the matter because he doesn't want me to be on. He appealed to the court unsuccessfully. So he filed an application. The application must have been denied. That's why it was unsuccessful for 2 judges, Justice Eniyebo and Justice Doche, to be taken off. So Justice Eniyebo is saying that, whilst I don't know him, just look at the circumstance of the matter and the record available, you will see that it's an incongruous story. That's what it is. Okay. The records further show that the Chief Justice was the only judge on a panel who recently, on 31st March, dissented in an application at the instance of the plaintiff in favor of the respondents, the Ghana Telecommunications Company Limited. Okay, so the CJ is saying something else, that there was another matter. One of these matters in between the real ruling, some things come up. Sometimes the lawyers call it interlocutories. So one of these matters of, if you like, sub-matter, interlocutory, the panel, the entire panel ruled in favor of this gentleman, the one in the matter, the one who is fighting with Afrifa over money, the one who is alleged to have said that the Chief Justice has demanded bribe from him. There was a ruling in his favor, but it was Justice Eni-Yeboah who was the only judge who dissented. So this is a conclusion of the matter. The lawyer's case has questions, fundamental questions that anyone should pick up. I didn't hear that in the political press conference. No problem. The Chief Justice has also said something. So the matter is going to the General Legal Counsel. We also know that ASEPA have filed an application at the Speaker's desk to the Speaker's office in Parliament, asking for the Speaker to do an inquiry into this matter. And they have also filed to the Commission of Human Rights and Administrative Justice. Let's go and look at the members of the General Legal Counsel, and then we can make our point about agreeing with the NDC on this matter. They will agree with the NDC on the position that this is a matter of high public interest. So they may have to be a public hearing, number one. Number two, that the Chief Justice may have to recuse himself. Justice Eni-Yeboah, here in your screen, is the chairman of the General Legal Counsel. He's also the Lord Chief Justice. Justice Jones-Doche, against whom an application also was filed, is also on the General Legal Counsel. There's Justice Paul Bafoboni, who incidentally is the chairman of the Disciplinary Committee of the General Legal Counsel. Justice Bafoboni is the chairman of the Disciplinary Committee. So we do not know whether Justice Eni-Yeboah is a member of the Disciplinary Committee. But if Justice Eni-Yeboah is not a member of the Disciplinary Committee, I will assume that he's not a member of the Disciplinary Committee, because he's the chairman of the General Legal Counsel. But Justice Bafoboni chairs the subcommittee on discipline, and that's where this matter is going. So I will assume that Justice Eni-Yeboah is not a member of that committee. Justice Bafoboni is chairing it. Next also is Justice Yao-Pao. No nonsense, they call him. No nonsense Yao-Pao is also on the General Legal Counsel. Next is the learned Attorney General and Minister of Justice, the Honorable Godfrey Dame, is also on the General Legal Counsel. And then you have Mr. Alfred Tuah-Yeboah, also a member of the General Legal Counsel. And then you have Mr. Justin Amenuvo, the famous lawyer for the Electoral Commission in the election petition, also a member of the General Legal Counsel. And then you have Dr. Raymond Atuguba. He's a dean of the Faculty of Law at the University of Ghana. He's a member of the General Legal Counsel. And then you have Mr. Maxwell Opoku-Agyeman, who is the Director of Legal Education and also a member of the General Legal Counsel. Then you have Anthony Forson, the president of the Ghana Bar Association. He's also a member of the General Legal Counsel. And Christopher Archer, also nominated by the Ghana Bar Association, a member of the General Legal Counsel. So that's what we should expect. So the disciplinary committee is chaired by Bafoboni, but we are building a serious country. And so give me the Latin maxim, Nemo Judas in Cosa Sua. Let me share that, and then let me agree with the NDC on that. Because of this Latin maxim here, Nemo Judas in Cosa Sua, nobody should be a judge in his own case. No judge should preside over a matter in which he has a personal interest or involvement. It's a canon of natural justice. So this canon of natural justice is very important. And so I agree with the National Democratic Congress. The NDC's press conference today called for this, Nemo Judas in Cosa Sua, that a man must not be a judge in his own cause. So the learned Chief Justice, we will add our voice to the call. Learned Chief Justice must not be a judge in a matter in which he has a personal interest. He has been personally accused of something, so we believe that he will not be in. And also to the public interest, we think that our society is developing in a certain way. The public interest in legal matters came to an apogee in America during the O.J. Simpson trial, where there was pressure on the U.S. court that the matter must come on television. The trial must be televised so that people can see the jury, read their body language, and hear the arguments of the lawyers, because there was concerns that there will be some racial decisions taken within the context of the matter, either against Simpson or for him. So that's where this matter started from. And it has since generated such significant interest up onto Ghana in 2012, where we had an election petition that was televised. We have had another election petition that has been televised. Given the high public interest in this matter, given the sensitivity of this matter, given the sacrosanct position of the judiciary and the head of the judiciary, the Lord Chief Justice, I believe that it is necessary that the General Legal Counsel must allow a televised event so that people can see the witnesses, people can see their body language, people can hear them, and then people can see the way the proceedings are conducted, so that by the time the verdict comes from the General Legal Counsel, everybody is satisfied in himself that this person's allegations are founded, this person's allegations are unfounded. We beg the General Legal Counsel that let us achieve another epochal success in the jurisprudence of our country by televising this all-important hearing of the disciplinary committee of the General Legal Counsel. And it will be a feather in the cap of the judiciary and will strengthen the canons of justice in this country. I end my story here, but I cannot end without showing you again Johnson Asiedu Nkatia.
Ladies and gentlemen of the media, the difficulty, however, with this is that the investigations would concern the Chief Justice, who is the subject of the bribery allegations in this matter, and in whom disciplinary authority against judicial officers is vested under Section 18 of the Judicial Service Act. The Judicial Service Act provides that the Chief Justice is vested with the authority to discipline all the judicial officers in the country. But now you have allegations being made against the person who should be the disciplinarian. So that is a difficult situation there. Therefore, good governance dictates that the Chief Justice steps aside during the pendency of the investigations by the Judicial Service relative to the issue of alleged misconduct on this part as a Supreme Court judge. That is, if we decide to go according to that route, then it means that the person who is the disciplinarian cannot be disciplining himself. So if we want to go according to the Judicial Services Act, then the person who is the subject of the allegation must step aside so that other officials will take over during the pendency of the investigation. And if he is cleared, he returns back to post. If otherwise, then it will all come out of the investigation. As I have said, the Chief Justice cannot be a judge in his own cause, hence cannot set up a committee to investigate allegations of misconduct against himself.